Welcome to today's online series webinar on Section 25 of the Charter, Indigenous Laws in Canadian Courts, hosted by the Centre for Constitutional Studies at the University of Alberta. I'm Pat Parody, the Executive Director of the Centre for Constitutional Studies, and I will be your moderator today. Now, as this is a webinar, many of our audience members are watching from across Canada, and some, as it turns out, in different parts of the world. And so I would encourage you to reflect on the land at your respective location and to think about those who came before you and who called and continue to call the land home. As I respectfully acknowledge that the Centre for Constitutional Studies is located on Treaty 6 territory, which is the ancestral gathering place of the Cree, Saulteaux, Inuit, Métis, Nakota Sioux, Blackfoot, and Inuit people, and whose histories, languages, and cultures are the ground structure of our shared, vibrant community. Now, before I introduce our guest speaker, Ryan Beaton, I'd just like to note that ask you to note that the chat function for this webinar is disabled, but you are certainly able to ask questions at any time during the webinar. And our speaker, Ryan, will get to as many of your questions at the end of his talk as possible. And he will probably speak until about 1/4 so we'll have about 15 minutes for questions. Hopefully, we'll get to all of your questions. Also note that you will be receiving a little link to a survey after the webinar, and we'd very much appreciate it if you could give us your feedback. And the webinar is being recorded. If any of you would like to see it after today, it will be up on our website, the Centre for Constitutional Studies website, in a day or two. So now to introduce our talk and our speaker. Earlier this year, the Supreme Court of the Yukon released a decision in a case where a member of the Vuntut Gwitchin First Nation brought a charter challenge alleging that the Vuntut Gwitchin First Nation's Constitution violated her right to equality under the Canadian Charter of Rights and Freedoms. And one of the questions she raised was whether the charter applied to the Vuntut Gwitchin First Nation Constitution. In deciding the case, the court discussed the meaning of Section 25 of the Charter. It's a section we rarely hear about. And so the case provides some law, finally, on the interpretation of that section and on the application of the Canadian Charter of Rights and Freedoms to an Indigenous constitution, one that is considered supreme law by the Vuntut Gwitchin First Nation. It also provides direction regarding the interaction between Section 25 of the Charter and Section 35 of the Canadian Constitution, a section that is outside the Charter and that affirms existing Aboriginal and treaty rights. So our speaker, Ryan Beaton, is eminently qualified to address these many interesting and complex issues. He holds a PhD in philosophy from the University of Toronto, a master's in science in mathematics from McGill. He received his JD from Harvard Law School in 2013, clerked for Chief Justice Beverly McLaughlin at the Supreme Court of Canada and for the Court of Appeal of Ontario. He is a lawyer with jurist power in Vancouver, and he practices in the areas of Aboriginal constitutional and administrative law there. He is also a PhD candidate at the University of Victoria, where he focuses on the evolving conceptions of Aboriginal title and Crown sovereignty in Canadian case law, research that makes his presentation today on Indigenous laws in Canadian courts right up his alley. And so over to you, Ryan.
Thank you, Pat, for that introduction, and thank you for having invited me to give this talk today. As I'm speaking to you from Victoria, I'd like to acknowledge that this part of Vancouver Island is unceded territory of Lekwungen and WSÁNEĆ peoples. And as Pat was saying, I will speak about the Vuntut Gwitchin case, as well as the Section 25 issues that it raises. And I was looking again at the poster that was put out for this talk, and note that it frames the issue quite reasonably as one of whether the Canadian Charter of Rights and Freedoms or the Vuntut Gwitchin Constitution should prevail or prevails in the case of a perceived conflict between them. So, I mean, an initial question is, whether this is the right way to think about the case. So the parties certainly did frame it that way before the court, but the Supreme Court of Yukon rejected this way of framing it as either the Charter or the Vuntut Gwitchin Constitution. So I'd like to unpack how that played out in the case and how the issues were resolved, and we can think together whether, what's the right way to frame this case and think it through. So in order to take you through all of that, I propose the following rough roadmap for this talk. I'll begin by speaking to a little bit of the background of the case. Who were the parties? What did they argue before the Supreme Court of Yukon? Then take a step back to discuss the key legal issues in play, particularly the key sections of the Canadian Charter and Section 35 of the Constitution Act 1982. I'll say a few words also about inherent Indigenous sovereignty, since I think it's important not to get lost in the technicalities or not to forget that at the heart of the case really is the question of how Indigenous sovereignty, inherent self-government, jurisdiction, whatever term we use for that conception, how it's going to find its space and what shape it's going to have in the Canadian constitutional landscape. So that's the heart of the case, but it's refracted through a number of provisions of the Charter, Constitution, and the legal technicalities that go with that. So once we've done a bit of an overview of these key legal issues, I will turn back to the case, and I'll discuss how they were resolved in Vuntut Gwitchin and what that might signify for Canadian law moving forward and for Indigenous state relations. So who are the parties to the case? Well, the Vuntut Gwitchin First Nation was the respondent. And I should say most of the facts I'll provide are taken from the case itself. So I hope the court was accurate in what it said. I poked around to do a little research on my own, but largely this information is drawn from the reasons of the court put out in June. So the First Nation is in northern Yukon. It's part of a family of Gwitchin First Nations. These are Athabaskan-speaking peoples with traditional territory spanning parts of Alaska, Yukon, and Northwest Territories. The VGFN has comprehensive land claims and self-government agreements with Canada and Yukon. These were reached in the mid-90s. And VGFN has adopted the Vuntut Gwitchin Constitution. So it has adopted its own constitution by vote through Legislative Assembly, open to all Vuntut Gwitchin citizens, as a modern expression of its ancient self-government. This is from paragraph 8 of the reasons of the Supreme Court of Yukon, explaining that the Vuntut Gwitchin have a large traditional territory in North Yukon, situated around the seat of the Gwitchin community today is in Old Crow. That's where they have their seat of government, and as I understand it, their principal community on the traditional territory. And this fact I was quite stunned by, that I didn't realize the territory in that part of North Yukon was unglaciated during the last ice age, and that there's evidence suggesting human use and occupation back as far as 40,000 years. And this is just a Google Map snapshot to give you an idea of where it's located. The red drop is, according to Google, at Old Crow itself, so quite far north in Yukon. And this is a picture, I understand, from Vuntut or Old Crow flatlands in Vuntut National Park, created as part of the land claim settlement between Canada, Yukon, and Vuntut Gwitchin First Nation. And there's a number of quite stunning pictures online if you want to poke around. So the petitioner in the case, the person who brought the case, was Cindy Dixon, a Vuntut Gwitchin citizen living in Whitehorse. And she explained to the court, so again, this information is presumably accurate, at least as of June of this past summer. So she was a Vuntut Gwitchin citizen living in Whitehorse, who explained to the court that she would find it difficult to relocate to Old Crow, in part because of medical care required by her teenage son. And she wanted to run for a position on VGFN Council, and to serve in that capacity while continuing to live in Whitehorse. I should maybe have mentioned, if I remember correctly, the VGFN Constitution created 4 principal bodies of government for the First Nation. There was a council for which Ms. Dixon wanted to run. There was an Elders Council, there's a General Assembly consisting of all Vuntut Gwitchin citizens, and a Youth Council. So she wanted to run for a position on the council, which I understand to be the principal legislative body of the Vuntut Gwitchin First Nation. So this was in 2018. She sent her nomination papers in, but they were rejected because the Vuntut Gwitchin First Nation Constitution required VGFN citizens to be resident on settlement lands in order to be eligible to be elected as chief or councillor. So in that case, she was prevented from running for council. Now, the court noted that since that occurrence, there has been an amendment to the residency requirement in the VGFN Constitution. So it has been softened, I suppose you'd say, to read as follows now. If an eligible candidate for chief and/or councillor does not reside on settlement land during the election and wins their desired seat, they must relocate to settlement land within 14 days. So the obvious advantage of this provision for someone who wants to run from outside settlement lands is they wouldn't have to relocate unless they win their election. And this is the provision that was challenged by the time the case got to court. So Ms. Dixon was challenging this provision, saying that even this modified version violated her charter rights, and she was asking the court to find such a violation. So what were the arguments? Well, the primary argument advanced by Ms. Dixon was that this residency requirement violated her equality rights under Section 15 of the Canadian Charter of Rights and Freedoms. And that argument rested heavily on a case decided by the Supreme Court of Canada in 1999 called Corbière, which I will return to later in the talk. The Vuntut Gwitchin First Nation countered that the charter did not apply to its bodies of government or its laws, as these were expressions of inherent Indigenous powers of self-government. And they also added that nothing in the self-government agreement between VGFN, Canada, and Yukon stated expressly that the charter applied. There were provisions that the court pulled out from the self-government agreement that did say that it has to be consistent with the Canadian Constitution, that all Vuntut Gwitchin citizens have access to the same rights, protections as other Canadian citizens. So there was language for Ms. Dixon and the court to point to, suggesting, or that would be the basis for an argument that the rights and freedoms in the Canadian Charter were available to a Vuntut Gwitchin citizen, and arguably therefore should be something that a Vuntut Gwitchin citizen can assert against Vuntut Gwitchin government and laws. On the other hand, Vuntut Gwitchin First Nation pointed out that a modern self-government agreement concluded between Canada, BC, and the Niska Nation was explicit in saying the charter did apply. And so there are roughly contemporaneous examples of self-government agreements that say explicitly the charter does apply to the Indigenous governing body. So VGFN here could argue that the absence of such a provision in their self-government agreement meant the charter did not apply. All of that to say the self-government agreement was unclear as to whether it intended to apply the charter to VGFN government. VGFN also pointed to Section 25 of the Charter as a shield that ought to protect it from application of the Charter. So briefly, those are the issues that were brought to the court. Now, to really make sense of them and how a court would begin thinking about them, we have to take a bit of a step back and look at some of the provisions in play. And as I say, the fact that Indigenous sovereignty and self-government is the heart of the case, or is a major motivating factor in the way things are thought about in this case by all the parties and by the court. So, Canadian Charter Section 15, this is the provision that Ms. Dixon was relying on, was claiming provided her with rights that she could assert against the residency requirement in the Vuntut Gwitchin First Nation Constitution. So this provision is an equality provision that says every individual is equal before and under the law and has the right to equal protection and equal benefit of the law without discrimination. And then it provides a number of bases on which discrimination is prohibited: race, national, ethnic origin, color, religion, sex, age, mental, physical disability. Now, the Supreme Court, the courts of Canada have said this is not a closed list. So if a petitioner or plaintiff can show there is another kind of characteristic or another characteristic that is of the same kind, that is a marker of traditional forms of discrimination that indicates a group of people that have suffered traditional or historical prejudice and discrimination, that the courts can, they've done this rarely, but they can recognize what's called an analogous ground. So another ground of discrimination that's not explicitly in this list, but that that can be added to it for purposes of someone invoking their Section 15 rights. Now, in Corbière, the case I mentioned, the Supreme Court recognized what it called aboriginality residence as an analogous ground under Section 15. And that essentially meant people living off reserve who do have Indian status. And in that case, there were members of the Batchewana band in Ontario who brought a challenge to an Indian Act provision that prevented them from voting in Batchewana Band Council elections if they lived off reserve. And in that case, the Supreme Court of Canada said, gave them the victory, said, yes, you're correct that the provision in the Indian Act violates your Section 15 rights by prohibiting you from voting in band council elections if you live off reserve. And the court noted, I mean, part of the court's reasoning was that people with Indian status living off reserve have suffered a great deal of historical prejudice and discrimination, in large part because many of them live off reserve for the reason that they were enfranchised or otherwise stripped of Indian status and had legally to leave the reserve. So there's a whole history behind the court's recognition in Corbière of aboriginality residence as an analogous ground of discrimination. And that, as we'll see, came into play in Vuntut Gwitchin. Section 25 of the Charter, as Pat mentioned, has been certainly very little said by the Supreme Court of Canada about it, not much in the other courts either. It is in some sense at least a shield for certain Aboriginal treaty and other rights from the application of the Charter. So it says the guarantee in this Charter, the Canadian Charter, of certain rights and freedoms shall not be construed so as to abrogate or derogate from any Aboriginal treaty or other right or freedom that pertains to the Aboriginal peoples of Canada, including those recognized in the Royal Proclamation and any rights or freedoms acquired through land claims agreements. And I'll just highlight one aspect of the wording that's gotten a lot of attention. It says, the Charter can't take away from any Aboriginal treaty or other rights or freedoms. And that's significant in the discussion of how Section 25 relates to Section 35 of the Constitution Act, 1982. So part of the same document as the Charter, but this is the first provision that's outside of the Charter proper. And it recognizes the existing Aboriginal and treaty rights of the Aboriginal peoples of Canada. So as a number of people have pointed out, the language here is Aboriginal and treaty rights. If that same language were found in Section 25, Aboriginal and treaty rights, we might think, well, what Section 25 does is simply shield any rights found in Section 35 from application of the Charter. But this language in Section 25 is broader. It says that the Charter won't abrogate or derogate any Aboriginal treaty or other rights. So there has been considerable speculation as to what will count as other rights. What's the character of the rights that attract Section 25 protection? And maybe I'll briefly add, that people have, so the argument's been made that if it said only Aboriginal and treaty rights in Section 25, it would be essentially a hollow, meaningless provision because Aboriginal and treaty rights are already protected in Section 35. And so it doesn't need any extra protection. I don't find that convincing, because if we had no Section 25, and if a court found that there was a conflict between someone's, say, Section 15 rights and a right of self-government protected under Section 35, that would mean the court is finding a conflict between, or a tension between, two constitutional provisions. And the courts would normally not just say one provision trumps another. You know, they might try to interpret to avoid a conflict. They might balance in some way, but all of that suggests a kind of compromise between two constitutional provisions, a balancing, or a kind of drawing lines. Whereas Section 25 comes in and says, no, if there is a conflict, or if there is some perceived conflict between a charter right or freedom and a Aboriginal or treaty right, the charter cannot eat into or infringe, derogate, or abrogate from the Aboriginal or treaty right. So even if Section 25 said only Aboriginal treaty rights, I do think it would still have a function in making clear that Aboriginal treaty rights are protected against any form of compromise or balancing against charter rights. That said, it does also protect other rights, and so there's an outstanding question in Canadian law, exactly the scope of Section 25 protection. I'll come back to this Section 32, but it's also at the heart of this case, because Section 32 of the Canadian Charter defines or spells out where the Charter applies. You cannot invoke the Charter normally against a private party. You have to invoke it against an exercise of governmental authority, legislative or executive, and the Section 32 explains that that means the Charter applies to Parliament, Government of Canada, and in respect of all matters within the authority of Parliament, including all matters relating to the Yukon territory. And it also applies to the legislature and government of each province. So if we just read this without context, we might think, well, it doesn't apply to an Indigenous governing body because they're not listed. So that's a plausible argument, a strong argument. On the other hand, the interpretation of this provision has been that the real key is what's within the authority of Parliament. So if Parliament delegates governmental capacity to hospitals, school boards, or other entities as vehicles for carrying out government policy and laws, the courts have found to that extent the Charter may apply to those bodies. So there is often a question in law as to whether a particular institution or practice at an institution falls within these provisions. So as we'll see, that came up in the Vuntut Gwitchin case in terms of trying to decide whether exercises of governmental power on the part of the Vuntut Gwitchin First Nation were exercises of delegated authority from Parliament that would bring it within the application of, or within the scope of Section 32. That's a lot of technical stuff to throw at you, and I think it will help when we get to the concrete way it played out in Vuntut Gwitchin First Nation case. But I do think it's worth remembering again that at the heart of there's all these technicalities, but the real issue is what's the space and the shape of Indigenous sovereignty in the Canadian constitutional landscape. The Indigenous sovereignty was the obvious reality when Europeans arrived in what is now called North America. And this was something that was clearly accepted, recognized by European treaty negotiators. This is, one example taken from countless that could be given, but this is from the Royal Commission on Aboriginal Peoples report. They noted that Europeans saw no difficulty adapting to Aboriginal protocols, legal formalities, and ways of negotiating. They learned to make condolence before a conference with the Six Nations, to give and receive wampum, to smoke the pipe of peace on the prairies, to speak in terms that were drawn from and familiar to Indigenous legal cultures. I also note a recent case in the Ontario Superior Court of Ristoul that makes a very similar point and details a number of the way European treaty negotiators adopted Indigenous protocols and showed recognition and respect for Indigenous legal traditions in what became Canada. The Supreme Court of Canada itself has stated that treaties serve to reconcile pre-existing Aboriginal sovereignty with assumed Crown sovereignty. And certainly we can debate the extent to which the Supreme Court has followed through on these kinds of statements in its decisions and its doctrine. But the statement itself is quite striking for a high court in quite clearly giving a priority to Indigenous sovereignty, noting that Aboriginal sovereignty is what was pre-existing here. The Crown assumed or asserted sovereignty, and treaties are required for the legitimacy or the legitimacy of Crown assertions of sovereignty. So this, I think, is quite on point with a recognition that Indigenous sovereignty is the default setting in Canada. It's what the initial default position, and to the extent that there are treaties negotiated in good faith and respected on both sides that can legitimate certain Crown assertions of sovereignty. But we find the courts with more and more of these statements recognizing this reality. This last statement on this slide is from a recent 2018 federal court decision, noting that Indigenous legal traditions are among Canada's legal traditions. They form a part of the law of the land. And the same case, Justice Gramont at the federal court, of course, acknowledged that despite this reality, the overall tendency for a long time by Canadian courts, also Canadian governments, was to deny and suppress Indigenous sovereignty. Gramont notes the UN Declaration, cites one of the articles. I won't read it fully, but there's a number of these developments. The UN Declaration, Canada's expression of full support for the UN Declaration and commitment to implementing it. Canada in 2018 put out a number of principles respecting the Government of Canada's relationship with Indigenous peoples, recognizing Indigenous self-government as part of Canada's system of federalism. BC has adopted an act intended to implement the UN Declaration. So, it could go on and on. There's a number of developments recently that, I would summarize by saying there's just no longer a question of whether Indigenous sovereignty, self-government, jurisdiction is recognized in Canadian law. It is, but the question is what shape it will take. And the Vuntut Gwitchin decision reflects that. No one was challenging the reality of Indigenous self-government, but the case shows how courts may now be pivoting to more technical or concrete specific issues of the exact shape and scope of Indigenous self-government and sovereignty in particular cases. So this brings us back to Vuntut Gwitchin and how this bundle of issues was ultimately resolved and the context of the particular dispute there. So to come back to section 32, an initial question for the court was, well, is there any argument that the charter is even brought, the Vuntut Gwitchin First Nation government is at all brought within the scope of the charter by this section? This is the sort of first matter the court had to think about in thinking the relation between the charter and the Vuntut Gwitchin First Nation Constitution. So the court, what it said is that there is merit in both the argument made by the Vuntut Gwitchin First Nation that its authority in its self-government and its enactment of its constitution, and in particular the adoption of a residency requirement for councillors. There's merit in the argument that all of that flows from inherent Vuntut Gwitchin First Nation sovereignty, jurisdiction, self-government. And as we'll see in a minute, the court essentially said the adoption of the Constitution was an exercise of inherent self-government powers. But the court said there is also merit to the argument put forward by Canada and Yukon that and Ms. Dixon that the authority is derived from enacting legislation by Canada and Yukon. And the court it clarified that by saying really what's going on there is the federal legislation and the territorial legislation by Yukon makes the self-government agreement binding in Canadian law and in Yukon law generally against, not only on VGFN territory or among VGFN citizens, but more broadly. So it can be protected in Canadian courts, it's recognized by the government and federal law, et cetera, and that this, in effect, brings the binding force of the state to the exercise of VGFN self-government authority. So in a sense, the court is saying both. It is an exercise of inherent self-government powers by the First Nation, but it is also joined or enhanced or extended by the enabling legislation passed in Parliament and the Yukon legislature. So the conclusion that the court reached in terms of the applicability of the charter was that, yes, in principle, Section 32 brings the VGFN government, including its adoption of a constitution and more particularly the residency requirement, within the scope of the charter. So the charter does apply. The court said it applies whether we view the VGFN constitution as an exercise of inherent right or an exercise of VGFN self-government agreement implemented by federal and territorial legislation, that both are part of Canada's constitutional fabric. So in summary, yes, the court said Section 32 in principle makes the charter applicable to the VGFN government, including its constitution. Which meant the court then had to decide whether Ms. Dixon had made out a violation of her Section 15 rights by the residency requirement in the VGFN constitution. And I'll focus on the Corbière argument, which is at the heart of the court's reasons. And the court, so again, the Corbière is the case where the Supreme Court of Canada found that the Indian Act discriminated against off-reserve band members who were prohibited from voting. And the court in Corbière distinguished and said, this is a very different case, because what was at issue in Corbière was a federally imposed requirement through federal legislation in the Indian Act that was not an expression, that restriction of the vote to members of the Batchewana band who lived on reserve was not an expression of Indigenous self-government, but was just imposed through a federal act, the Indian Act. Whereas here we have the Vuntut Gwitchin First Nation citizens voting at a General Assembly, exercising their inherent right of self-government to adopt a constitution, including the residency requirement. And the court also noted this other significant difference, that nothing in the VGFN constitution prevents citizens from voting if they live off of settlement lands. And no one's deprived now of running for office. The restriction is quite different from that in Corbière. Here the restriction is just that if you are elected to council, the VGFN council, you must relocate to settlement lands, meaning in practice Old Crow. And in order to make out a violation of Section 15, the plaintiff, the petitioner, in this case Ms. Dixon, has to show that the distinction drawn, so the fact that she lives off settlement lands, and the effect it has on her is discriminatory, meaning it perpetuates some form of historical disadvantage or discrimination or stereotyping. And the court said here that really is not the purpose, as the court understands it, of the residency requirement. That in the court's view, the residency requirement is about enhancing the homeland and protecting it for all VGFN citizens. And on that basis, the court said it doesn't find a violation of Section 15 here. It's not discriminatory to have the residency requirement in the VGFN constitution. There's a minor qualification to that I could discuss in questions, but I won't discuss it more here other than to say the court found the 14-day requirement that a person who is elected to council has to relocate to Old Crow within 14 days of the election. That was an arbitrary restriction, and it removed that part of the residency requirement. So actually, because the court found there's no violation of Section 15, it could have logically stopped there and said, you know, the court doesn't have to consider Section 25 because there's no violation of the charter made out, no apparent collision between the VGFN Constitution and the Charter of Rights and Freedoms. So no need to consider whether Section 25 would shield the VGFN government and laws from charter review if there was a violation. But the court said clearly with an eye to a possible appeal that it would consider the issue. So it said, you know, imagine I, court, am wrong about the violation, that there really is a violation. I will now consider whether Section 25 protects, shields the VGFN residency requirement from the application of Section 15. And so there's a number of issues come up. I've highlighted two here, the bigger one, or the main one I'll talk about, whether Section 25 shields the residency requirement. There's also a question of whether the order of analysis the court engaged in makes sense. Should the court first have considered whether Section 25 is applicable here? And if so, not gone through with the Section 15 analysis, said, well, there's no need to look at a full Section 15 analysis, because in any case, the Section 25 will protect the residency requirement from any conflict. So I'll talk about that if there's time. Otherwise, I could address it in questions. There's another issue that wasn't addressed by the court that involves the notwithstanding clause of the charter. Again, I won't have time to discuss that in the talk, but would be happy to take questions on it. So again, this is the language of Section 25 and the language of Section 35. So one question would be, is the adoption of the Constitution and residency requirement an exercise by the VGFN of an Aboriginal right of self-government? Or even if not that, is it an exercise of another right that pertains to Aboriginal peoples of Canada? Now, the court said, yes, that Section 25 provides some shielding of the VGFN Constitution, but it didn't take either of the maximal positions advanced by the party. So the court noted that Ms. Dixon's view was the purpose of Section 25 is to protect Aboriginal rights from abrogation by the Canadian state. So for example, in Corbière, where you have federal legislation arguably impinging on the rights of Batchewana band members to vote for their leadership, she's saying that's the kind of thing that might trigger Section 25 protection, because it's an infringement by the Canadian state on, or by a Canadian state law on First Nations government. Or if there were a restriction on hunting or fishing rights, as happened in a 2008 case, RV Cap, where the non-Indigenous people challenged certain fishing licenses given to Indigenous peoples on the basis of Section 15. And there you might have a situation where Section 25 would protect an Aboriginal right from provincial or federal legislation. But she was saying it doesn't protect First Nations governments from their own citizens appealing to the charter. That was the distinction she wanted to make. The court said that reject that position because it would really put a First Nation government in the same basic position as non-First Nations governments. In other words, the citizens of the First Nation could invoke the charter fully against the First Nations laws and government, and that really would not give much substance to Section 25 at all. So the court settled on this statement of purpose for Section 25. It's to ensure that First Nation self-government rights can be woven into Canada's constitutional fabric and protected when courts seek to reconcile Aboriginal rights, treaty rights, or other rights and freedoms with interests of all Canadians or with the Canadian constitutional landscape as a whole. So the court concluded that the residency requirement here ought to be protected because of its constitutional character. This we could unpack more in the questions, but this was kind of the court's approach based on Supreme Court language to what are the other rights protected by Section 25. In a 2008 case, a majority of the Supreme Court suggested, well, those of a constitutional character surely get protection, or that might be the test. The court here noted that's pretty vague. It's not going to always be easy to say what's a right of a constitutional character. But in any case, this adoption of a constitution surely qualifies. And so the VGFN adoption of constitution, including the residency requirement, is an exercise of a right of self-government that has constitutional character, and so it does attract Section 25 protection. Now, this is the other issue. I'll just tee it up. If there's any interest, we could discuss it further, or other questions if there's something that people would be more interested in hearing. But the Supreme Court of Canada in 2008 decision I mentioned, RV Cap, split 8-1. There was one Justice Bastarash who took the position, when there seems like there may be a conflict between Section 15 and a right protected by Section 25. So in this case, when Ms. Dixon comes to court, makes a plausible argument that the residency requirement infringes her Section 15 right if it applies, the court at that point should first consider, is there a right of self-government or another right in play that's protected by Section 25? And if so, then it doesn't need to go on to do the full Section 15 analysis. It could have first decided, say in this case, that the Vuntut Gwitchin First Nation Constitution is protected by Section 25, so no need to decide or consider in detail whether Ms. Dixon's Section 15 rights would be infringed by that requirement in the absence of Section 25. So the order could be significant in a number of ways. One, in not having a court say, yes, this person, in this case Ms. Dixon's rights, are essentially violated by the residency requirement, but it's shielded by Section 25. You might imagine the VGFN government would just prefer not to have that analysis, to just say their constitution is protected by Section 25. No need to give a detailed analysis of whether Ms. Dixon's rights under Section 15 are violated. The court in Vuntut Gwitchin took the position that first you should do the full Section 15 analysis and then ask about Section 25. The court seemed to feel that the need for a very contextual understanding of the situation was important to the Section 25 analysis, and that counted in favor of doing the Section 15 analysis first. So I'll leave it there. I mean, I think I don't know if we'd call Vuntut Gwitchin landmark, but I do think it's a very significant case in the way it shows maybe a shift that's been gradual or a bit of time in coming in how Canadian courts might approach these cases, insofar as there's just no dispute in the case that there exists an inherent Indigenous right of self-government. It's not, the fight isn't on that issue. The fight is more, okay, given that we all accept that point, how do we understand the place of that Indigenous right of self-government in relation to all these more technical provisions of the Charter, the Constitution, and the historical relation of Indigenous sovereignty and Canadian sovereignty. So I'll leave it there. I'm happy to take any questions or discuss other issues of interest or hear comments.
Well, thank you very much, Ryan, because that was a very complicated case to describe and explain. So I think you've done a marvelous job of taking us through it all very sequentially. So thank you very, very much. Now, I don't see any questions quite yet. And so one of the, oh, there comes one. I was going to ask my own. Here we go. And here's the first question. In what sense does Dixon's argument on Section 25 emasculate or undermine its protection for Indigenous Aboriginal rights?
So that's a great question. There's a lot that could be said. My understanding of what is fleshed out in the court's decision is the court is of the view that Indigenous people should be allowed in their collective self-government to develop their own way of understanding individual rights, the relation of individual rights to the collective as such, developing their own traditions in a modern context of how to balance that and maybe what exactly the content of individual rights will be. It's worth noting in this case, the Vuntut Gwitchin Constitution did have an anti-discrimination provision. Ms. Dixon did argue that her equality rights were also violated under that provision. The court didn't say much about it. Clearly, I suppose, found that that was not the case. So the court's position was, if you insisted that the exact bundle of rights and freedoms found in the Canadian Charter are available for citizens of First Nations to invoke against their own governments, to go to court and invoke, just as a Canadian citizen would against a Canadian or provincial government, that's going to force First Nations governments into too restrained a box in terms of developing their own traditions and style of government. And that's what I take the court, broadly speaking, to be talking about when it says it would emasculate their ability to develop their traditions or forms of government in a modern context as they would like, with their own expression of their own values and rights and freedoms and relationship between collective and individual.
Okay, thank you. I'm concerned about the court's decision that it wants to do a contextual analysis on the 15 before deciding on the 25, but anyway, we'll get to some of these questions. One is, has there been a decision about an appeal? And I think we were talking about this earlier, and I think you not clear on that.
I'm not sure. I meant to, phone the registry or ask, a colleague who's in Yukon whether they could look into this. I haven't had a chance, so I'm not sure. I would think it's quite likely, but possibly Ms. Dixon and VGFN government have discussed some compromise. I'm not sure.
Okay, thank you. Now, here's another question. Is there more work that could have been done by looking at the legislative history of sections 25 and 35? I may be wrong on this, but I believe that section 25 was the original provision about our Aboriginal and treaty rights in the draft 1982 Constitution, and 35 was only added later after hard bargaining from Indigenous leaders who felt that 25 wasn't sufficient. Does this matter at all?
It's a big question, and there's a lot of different views on how legislative history should play out in courts, and obviously there's a difference between a statute and a constitutional provision. There's an interesting article from, I think, 95 or so by Peter Hogg and Mary Ellen Turpel that I was rereading quickly before this talk, and one of the points they make is, it seems that for the drafters of Section 25, at least on the state side, provincial and federal representatives, probably had something in mind along the lines of what Ms. Dixon was suggesting, that, what's at stake are Aboriginal and treaty rights to hunt and to fish and access to resources, maybe land. And because obviously treaty rights are specific to Indigenous peoples and arguably therefore discriminate on the basis of ethnic origin or nationhood or race or other provisions in Section 15, there was a concern, well, if we don't protect treaty rights or other Aboriginal rights from the Charter and Section 15 in particular, there's going to be all kinds of challenges that non-Indigenous people will bring and say these are violations of our equality rights because we don't have the treaty right access to hunting, fishing, other resources, timber mining, all these things that have been asserted as Aboriginal treaty rights. And there's quite likely at that stage in thinking where there was less consensus or widespread recognition by the provinces and the federal government on Indigenous sovereignty, that was more front of mind than the question of how Indigenous self-government will relate to the Charter. So I say all of that to suggest caution about the use of the drafting history, in part because who do you look to? Do you look to the drafters and the negotiators on the government side, on the provincial federal government side? Do you look to Indigenous representatives? There's going to be such a wide range of interests that are clashing, and there's going to be evolution in the way Canadian society as a whole thinks about things like Indigenous sovereignty. So I think it's useful for sure to look at the history to understand what was intended, but I don't think that should govern or even necessarily be a very powerful part of an argument for the content of the Section 25, Section 35 today.
There was a lot of horse trading done in those days around those sections, yes. Okay, we have a number of questions now, 16 questions here. So I'm just going to get through as many of them as I can, Ryan. So one participant asks 2 questions. What is the mechanism within the Vuntut Gwitchin Constitution for adjudicating disputes about the interpretation of the Constitution?
So that would be interesting to go back and look at in more detail. Now, the court mentions that there is a provision in the Vuntut Gwitchin First Nation Constitution itself that says disputes can be brought to the Supreme Court of Yukon. Now, my understanding is that there's also a provision in the the self-governing agreement between Canada, Yukon, and Vuntut Gwitchin First Nation. This is a general, following a general format for all Yukon First Nations that requires a provision in the form of self-government taken by the First Nation to allow disputes to go to the Yukon Supreme Court. Now, I'd say all of that would want to go back and look at the provisions in detail. But my impression from reading the case and the provisions that come to mind now from the First Nation self-governing agreement and the VGFN Constitution are that there is a provision in the Constitution itself for having these kinds of disputes go to the Yukon Supreme Court, but that might be because it's required by the self-government agreement between VGFN Canada and Yukon, and it may be something of a placeholder for to allow the First Nation to develop its own dispute resolution processes. It may, under the Constitution, have some initial processes. I'm not sure that might go to the Elders Council or other things before it gets to court. But a big issue for a lot of First Nations is capacity. I mean, the court says there's about 260 VGFN citizens living in Old Crow, about 300 more living off settlement lands. So you can imagine that as they grow their institutions of self-government, now that they have this self-governed agreement, it takes time to build up capacity, and it's quite a small population. So they may also find that it's useful to have the court system there as a forum while they develop their own processes.
Okay, thank you. So you've focused on the interplay between the Charter and the inherent Indigenous jurisdiction and the role of Section 25. Can you comment on whether the same analysis can be used to apply to the interplay between the division of powers under the Constitution Act 1867 and inherent Indigenous jurisdiction?
I think yes, although another issue raised by, if I've understood the question, in the article by Hagen Turpel is, there's been a doctrine in Canadian constitutional law for a long time that's an entrenched notion that the division of powers in sections 91 and 92 of the 1867 Constitution Act are exhaustive. So there's this sort of idea entrenched in Canadian constitutional thinking, state constitutional thinking, that the powers divided between the province, the provincial legislatures and parliament are exhaustive, and they occupy all the field of sovereignty. Now, that notion will have to give way, clearly, if there's going to be a proper recognition of Indigenous jurisdiction as a third order of government that has its inherent jurisdiction not derived from any grant from the federal government or from the provinces. So I think basically the question is wide open at this point as to how Indigenous jurisdiction will relate to the division of powers in the 1867 Act. I think it's an open question, but I do think the Section 25 would at least influence the interpretation or the thinking of a court when it gets to that kind of an issue. Section 35 is also relevant. So one thing I'll say in answer to that, although it's just a hint of the kinds of issues that are popping up. As most of you probably know, there's a duty on the Crown, so the province or the provincial Crown or the federal Crown, to consult and accommodate Indigenous interests when the Crown acts in a way or proposes to act in a way that could negatively impact Section 35 rights. And there's a case from 2016 in BC Supreme Court where the province had signed an agreement with the federal government to rely on its environmental assessment of the, I believe it was the Enbridge pipeline. And in a case of pipeline through northern central BC. And the province said, well, we're just going to rely on the issuance of a federal environmental certificate. And the coastal First Nations brought this to court, saying the province has, under the division of powers in the 1867 Constitution Act, powers to legislate, to act with respect to environmental matters in the province, and those trigger duties with respect to Indigenous peoples who might be affected. And so it cannot abdicate that responsibility to the federal government. The court said, yes, you have to divide the honor of the Crown, the duty of the Crown by the heads of power, and that triggers responsibilities to Indigenous peoples. And what we're also seeing in the duty to consult cases is more Indigenous people saying, well, you have to use our governance mechanisms if you're going to carry through the project. And courts saying that's right, you have to at least have a meaningful discussion about that. So these are ways in which Indigenous self-government and jurisdiction keep seeping into the interplay between Section 35, the division of powers. And I haven't thought about Section 25 in the specific context of that kind of duty to consult case, but it could add another dimension as Section 25 gets more case law filling to it.
More traction.
Yes.
Okay. Well, we're just about at time here, but I'm going to take a few more of these questions because there are so many. And we now have 22 questions, Ryan. So is a First Nation having a custom election law in an analogous position to the Vuntut Gwitchin, or is a First Nation custom election law simply a delegation from the Government of Canada under the Indian Act?
No, in the same, roughly the same position. So I don't know if I'll find it quickly, but the 2018 case I cited from the federal court, the Pastion, so it's the citation is at the bottom here. That's exactly what Sébastien Gramont was the judge who said the Custom Election Act at issue in that case was an expression of inherent Indigenous jurisdiction. Section 25 I don't think came up in the case, but the court said, given that the election is an expression in part, that the protocols of the election are expression part of Indigenous self-government, an inherent right, there must be deference from the courts when it reviews those protocols or the law developed by the bands. So I would say, broadly speaking, yes, they'd be in a similar position, and Section 25, I would think, based on Vuntut Gwitchin, would offer some protection to custom elections.
Okay, thank you. Next question. This case mentioned that there will be a Vuntut court eventually. In the future, is that the ideal way that these types of issues would be dealt with? If so, would that reduce the need for Section 25?
I think yes, I think so. I have written on, there's an article in UNDRIP, UN Declaration on the Rights of Indigenous Peoples, Article 27, which says the state must develop in consultation with Indigenous peoples processes to adjudicate disputes about land claims, Aboriginal rights, etc. So my reading of that is it's a commitment to form dispute resolution mechanisms in consultation together with Indigenous people. So I suppose an Indigenous people could say, we're happy with going to Canadian courts, we agree on that. But if not, then I think there's a requirement under UNDRIP to arrive at some other kinds of mechanisms of dispute resolution. And I think that would include Indigenous courts, or in cases maybe where there's conflict between Indigenous law and federal or provincial law, some form of mixed body that has representatives of the Crown and representatives of Indigenous peoples as adjudicators. And that might be another crucial institutional means of bringing Indigenous law more fully into the Canadian constitutional landscape, maybe building on some of the co-management mechanisms that already exist, for example, with the Haida Nation and BC and Canada.
Okay, now can a sovereign Indigenous nation give away its sovereign power through a territorial agreement with Canada? Wouldn't that, and if so, wouldn't that be contrary to the norms of sovereignty and international relations?
That's a fascinating question. So if you read the Chilcotin Nation decision, the 2014 decision of the Supreme Court of Canada on Aboriginal title, one way of reading the case, the way I tend to read it, is that the court shifts from thinking of Aboriginal title as a property right or kind of property thing to a more jurisdictional issue, and says one of the things about Aboriginal title is its use cannot be used in ways that would undermine its continued use or value for future generations. So arguably, that might be a restriction on transferring away the sovereignty. On the other hand, the court has a long history of understanding Aboriginal title as something that can be ceded to the Crown, only to the Crown. You can't sell it to anyone else. So that might suggest, well, now the court's imagining the jurisdictional aspects of are part of Aboriginal title, and that's always been something that could be surrendered through a land claims agreement. So I think the weight of Canadian law would suggest maybe it is something that can be ceded, that has been ceded at times, but I think the ground is shifting quickly, and that might not be the view for long.
Okay.
At least there's a debate. I think it's unclear is how I would head.
I'm just going to read a note that's been sent by one of our participants who says that evidently Dixon has filed an appeal earlier this summer seeking a declaration that the residency requirement violates the section of the Charter. And in a notice of cross appeal filed to the Yukon Court of Appeal on August 7th, the First Nation said that it was only appealing two portions of Justice Ron Beale's decision, is finding that the Charter applies to the Vuntut Gwitchin government Constitution and laws made by the government, and his conclusion that a 14-day time limit for elected members of Chief and Council to relocate to settlement lands violated the Charter. So clearly there has been an appeal. Now, I know we're a bit over time here, but I'm going to ask you one last question. I'm so sorry we couldn't get to all these questions. The questions are just fantastic. It's very difficult to choose any of them. I mean, I'm just going through them as we go. But the one question I'd like to leave you with perhaps is, are there aspects of the decision that you are critical of?
Well, I hate to sort of close on a maybe anticlimactic or minor note, but it's just in my head now because of the 14-day, that's being appealed doesn't surprise me, because the 14-day, it's very minimal analysis. The court kind of just says, you know, the provision is not discriminatory, the residency requirement. On the other hand, the 14 days is arbitrary and doesn't talk about whether Section 25 should protect that. It just kind of says it violates, it's arbitrary, and so that has to be struck in order to keep from a violation of Section 15. But doesn't, I have to go back and check for sure, but I'm pretty sure it does not then go on to say anything about whether Section 25 should protect that part of the residency requirement. And if you're going to have a residency requirement, maybe 14 days is too short, but there's going to be some limit, presumably. You'd want to put probably something specific so it's not litigated every time. So if the government has a right to put in the residency requirement, it is a very minimal analysis to say it doesn't have the power to specify the time limit. So I'm critical of what happened there. I'm not saying it's necessarily wrong, but the court should at least have done a Section 25 analysis with respect to that 14-day provision in particular.
Okay, well, I really hate to bring this talk to a close because it's so interesting, but we have promised people an hour and we're 5 minutes over, and so I'm going to just bring our session to a close today. And thank you so much, Ryan, for your clear-headed explanation. I mean, it was just really, yeah, the questions were great. And I'm just going to assume that you'd welcome any specific questions to you directly if people want.
Absolutely.
Yeah.
Google me, and if you want to email or anyway, I'm more than happy to discuss with anyone.
Yeah, because there are some really, really fantastic questions here, honestly. So I just want to thank you very much for your presentation and remind people that this presentation, again, was recorded and will be available on our website in a couple of days. And I'd also like to thank Alina Rietsma, our Public Legal Education Coordinator, and Martin Gotthelf, our Administrator, for their work in advertising and organizing the event. And I want to remind all of you, if you could please provide your feedback, given the link that you will be sent after this. We really do appreciate your feedback. And so I will also, I guess, lastly, want to thank you, the participants, for engaging so wholeheartedly with the session. It's been really, really an engaging talk. And I think perhaps given this, we need to have something similar sometime soon. So because there are so many questions out there about this area of the law, it's just so developing. So thank you again, and thank you to all of you who have been watching. Bye-bye.